Good morning, sir. Are you Vishal? Vishal?
Yes, ma'am.
And this is cause number 25 DCCR 0507. Mr. Vishal was previously in court, entered a plea of guilty to the state jail felony offense of criminally negligent homicide. This was unagreed. The plea was, I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
State has, Judge.
Are there any additions or corrections to the report?
Not from us, Judge.
Not from the state.
All right, then, Mr. Gertz, you may proceed.
Judge, we're asking the court to consider probation. This case is unique, I would argue, for a variety of reasons. First and foremost, this court is very familiar with me and my proclivities. I would try this case 100 times out of 100. When I walked in to talk to him the first time, he said, I want to accept responsibility. That almost never happens. He didn't shirk his responsibility. We can talk all day about the fog. We can talk about the Tex dot needs to get their act together with the shoulders on the highway, whatever we want to talk about. He wanted to take responsibility. And he said it from the first day. When was the last time you ever saw me come in and plead on the first hearing, plead guilty to a serious offense like this? Never. He wanted to do that. That was him wanting to do that. And so from that standpoint, it's a unique case. The other reason it's a unique case is there's no aggravating factors here. He's not intoxicated, he's not on his phone, he's not doing anything other than driving his vehicle. Now, what happened to these people in the end result is absolutely tragic. And again, he's taking full responsibility for that.
All right, guys, let's break this down. A guilty plea to criminally negligent homicide, no deal on the table, and the defense immediately leans into responsibility. They frame him as rare, someone who didn't fight, didn't deflect, just owned it. No intoxication, no phone, just a tragic highway moment. The strategy is clear: humanize him early and separate negligence from recklessness.
But I will tell you, Judge, if he'd had 5 more seconds notice, he wouldn't have been able to stop the vehicle. It had 10 more seconds notice, he wouldn't have been able to stop the vehicle. He's doing the speed limit, he's driving on the highway, and there are vehicles on his left and behind him, and there is a stopped vehicle on the interstate. I mean, there's not a scenario in which, maybe the injuries are less, but there's not a scenario in which this accident does not happen. And so, again, he's saying, I should have been more careful, I could have done other things, I could have fixed this. And the way he's saying that is with his plea, and also his statements here. He expresses deep remorse, he struggles to sleep at night, he feels guilty about what happened to these people. And again, there's nothing redeeming about the outcome for these decedents, these victims. But the reality is, this is a situation that is a terrible, tragic accident. He is trying to take responsibility. I think that is, again, at least from my standpoint, is somewhat unique. And I'm asking the court to at least consider the distinct possibility and the option here that you have to grant him deferred adjudication probation. He would give up his driver's license, he'll give up his CDL, he'll do whatever the court orders in order to comply with probation. But putting him in the state jail for another year and a half is not going to fix anything. It's not going to make it any better for these decedents. It's not going to make it any better for their families. It's not going to do anything to anyone other than just cause.
The defense doubles down on remorse. Sleepless nights, surrendered licenses, total compliance, everything short of a halo. They argue jail fixes nothing and that supervision would serve justice better. It's a pragmatic pitch: punishment versus productivity. The subtext is strong: this was a mistake, not a monster. But in fatal cases, outcomes often outweigh intentions.
Him to not be out in the world for a year and a half, and that's it. And so this court could supervise him. This court could oversee his continued acceptance of responsibility and also protect the public at the same time. So we're asking the court to consider doing that, and that is our request.
All right, thank you. Mr. Coleman,
Thank you. I'll be brief.
are there any holds? No.
I'll be
Go
brief,
ahead.
Judge. Mr. Gertz and I agree on one thing, that I, like him, would try this case up, as he puts it, 100 out of 100 times. Myself, Judge, this is no accident. This is pure negligence, as it is a definition of negligence. I'll spare the court. I didn't of showing the court the video. The tractor trailer that this defendant was operating today was equipped with dash cam, or a version of dash cam video that shows that the vehicle that he struck was not stopped. It was traveling at a slower speed with its hazard lights on, but it wasn't stopped. There was no fog, the conditions were clear, and there was no cars on the other side of this tractor trailer, really preventing it from even changing lanes. I have the video. The court, if it desires, can certainly watch the videos. Short clip. But Judge, I take issue with that recitation of how this all went down. I'd like to offer State's Exhibit 1. It's a certified copy of FBI records indicating that
Make
this
that
defendant...
2.
Make it 2?
Because states 1 would have been the plea papers.
And we have no objection to it.
It indicates, Judge, that this defendant illegally entered this country and he's a national of the country of India. Judge, I'm not here to make some type of a political statement or commentary. I'm just simply saying that it is a violation of federal law to enter this country illegally. And Judge, like any other violation of law, in any other case, you can take that into consideration in sentencing this defendant. And I'm asking you to take that into consideration in this case, Judge. So here's States 2.
No objection. States 2 is admitted.
Judge, I also offer State's Exhibit number 3, pursuant to a business record affidavit that's been on file. It is a photo of the victim in this case, Judge. 16-year-old victim in the short obituary of her, Your Honor.
No objection.
States 3 is admitted.
Judge, she was 16 years old, Judge. She had, at the dawn of her life, she'll never get to graduate high school, get married, do the things that people do. Judge, you can say today by your verdict just the amount of damage and harm this defendant has caused due to this negligence. I'll conclude with a couple of other things, Judge. This defendant went on to continue to live his life as business as usual in California after this accident while the investigation played out. After the investigation and the indictment, it took some effort on the part of our office in conjunction with the U.S. Marshal's Office to track down and locate this defendant. I'm not saying he was intentionally hiding or absconding. I'm simply saying it took a lot of effort by the federal law enforcement authorities to track him down, Judge. And also this business about this name and the alias name and whether or not he goes by no name given or goes by Vishaw. Again, the court can infer whatever the court wants to infer about why an individual would illegally enter this country and use at least one or maybe 2 different aliases, Judge. I'm asking for
The prosecutor dismantles the unavoidable tragedy angle. Dash cam footage, clear weather, a moving vehicle with hazards on. This wasn't fate, it was failure to react. Then he escalates, introducing illegal entry and aliases. Whether strategic or controversial, it reframes character. Add a 16-year-old victim's obituary, and the emotional gravity shifts hard toward maximum punishment.
And I am frustrated at the fact that all I can ask for is 2 years in this case, Judge. But I'm asking for the 2 years. In this case, I think this case warrants 2 years. Judge, if the court is not inclined to give it 2 years, I'm asking that the court deny the discretionary jail credit pursuant to my motion that I filed under Article 42A559 of the Texas Code of Criminal Procedure, Judge. And lastly, the family.
Say what you just said again?
It's in my motion that I filed, asking that the court deny the discretionary jail credit for state jail offenses.
Oh, okay.
It's 42A559C of the Code of Criminal Procedure, Judge.
Okay.
And lastly, Your Honor, the film is here for whatever it would be, for what that's worth, Judge. And I believe that the mother of the deceased would like to make a victim impact.
Thank you, Mr. Coleman. So it's my understanding that there is, at this point, immigration hold on Mr. Vishaw, correct?
Yeah, that's my understanding too, Judge.
Okay. So even though likely for him to be deported because he's here unlawful, you're asking for probation?
Well, Judge, there's not really another option, right? So I guess the question is, given the current status of our...
Now the focus pivots to immigration status. The judge questions the logic of probation if deportation looms. Defense argues deportation happens either way, so why not supervise him meanwhile? It becomes less about the crash and more about jurisdictional reality. The courtroom tension shifts from moral blame to practical consequence.
Immigration situation, I have no idea how ICE is going to handle this. What an ICE hold means is that if you give him probation, they've got 3 days to come pick him up. And if they don't come pick him up, then he's placed on probation. And what the court can then do is supervise him unless and until the federal government comes and deports him or attempts to deport him. The kind of alternative to that is he can sit and sleep on a cot that we're providing and eat food that we're providing and then be deported at the end of that. With a conviction or a deferred adjudication, he's going to get deported at some point anyway. So it doesn't really, the court, I'm not trying to be difficult, but this court's decision is not going to change the likelihood of his deportation, because a deferred will count as a conviction for deportation purposes. A conviction will count as a conviction for deportation purposes. So, again, we're asking the court for probation because of his acceptance, again, of responsibility here in this case.
All right. And I appreciate the acceptance of responsibility. I do. I appreciate, and I'm sure the family appreciates, not having to go through a trial and see what they had to live through over again. And so I will take that into consideration. Probation, to me, in a felony case, really of any kind, when someone is here unlawfully, doesn't make any sense. And again, I'm with Mr. Coleman. I'm not here to make a political statement on any of this, but if you're here unlawful and you've committed a felony offense, it just doesn't make sense that I would put somebody on probation where they're potentially still threat to the safety of our citizens. And the no name thing gives me some concern. Also, I feel like that is just potentially an attempt to avoid probably some issues with immigration and some issues with potentially this case. So what I'm going to do, again, I appreciate, and I'm sure the family appreciates, not having to go to trial. But I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide. Sentence you to a term of 20 months in the state jail prison. You will receive, I will give credit on that for any time that you've been in custody that the law gives you the right to receive. With regard to the state jail credit, I leave that up to the state jail authorities, and I'm going to deny the motion to deny that credit. That will be up to Mr. Vishaw in state jail. With good behavior, he'll get that credit just like everybody else. So I'm not going to deny that. It's based on, always has been based on how you behave in the state jail prison. And so just to deny that, it goes against the nature of that rule and that law, so I'm not going to do that. I'm going to hand you the trial court certification that shows there was no agreement, which means you do have a right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that to determine what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Gertz. Good luck to you, sir. Thank you, Mr. Coleman and Mr. Gertz. Okay. Did Ms. DeLage?
Deal with the matter.
Oh, I'm sorry. Yes. If y'all will have a seat, Mr. Kimler, can you move for a second so they can use that table? You can just have a seat over here and we'll go off the record for the victim impact statement.
The judge acknowledges responsibility but draws a firm line. Unlawful presence plus a felony equals no probation in her courtroom. Concerns about aliases and public safety seal it. 20 months in state jail, measured, not maxed. She denies stripping good time credit, keeping procedure intact. It's accountability with boundaries. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.